Hi, my name is Jason Lee, and I'm the founder of a company called Celent Innovations that automates the production of legal documents. I'm also an attorney licensed to practice law in New York, Massachusetts, and Michigan. I practiced law for 8 years at a private law firm, but nowadays I just represent one company, Celent, as in-house counsel. And one thing that my lawyers told me to tell you is that I am not your attorney. In this video, I'll talk about the non-disclosure agreement and general legal principles that apply. I'll share some of my observations in my experience and opinions in general, but you should not construe them to be legal advice applicable to your specific situation. For that kind of advice, you'll need to hire an experienced and licensed attorney in your state. And if you need help with that, I'll be happy to refer you to somebody if I can. So what is a non-disclosure agreement? NDA for short, and also known as confidentiality agreement. NDAs are used to protect confidential information, typically relating to business discussion or anticipated business dealings between the two parties. They usually are not entered into for the sake of buying silence, although from time to time, you hear in press about prominent people having used NDAs for that purpose. But in a normal business context, they're into to lay the groundwork for the parties to speak freely so that frank business discussions can be had, or send important documents without the fear of getting sensitive information out in the public. So say in an acquisition context, the buyer needs to know how much to pay for an asset or a company. And to determine its worth, you have to know how much money it generates. So if you're the seller, you might have to disclose who your biggest customers are and what you're charging them. All very valuable and sensitive information that seller might not normally volunteer, especially if the buyer is a competitor. NDAs are also used a lot in vendor or consulting context. So if you're a tech company and need to hire out developers, you might need to share your technical roadmap or even your source code before you hire them. I just want to mention two things. An NDA is not the only way to protect confidential information. So you can have non-disclosure related paragraphs like a mini NDA embedded in another agreement like a service agreement or an employment agreement, and that's very common. Usually NDAs come first and then get superseded by the other definitive agreement. And second, in a startup context, it's not customary to sign an NDA with your investors. Though there are some exceptions, like in hard sciences, where the patentability of an invention could be at risk, because until you file your patent application, you're not supposed to be talking about it freely, because once it gets out in the public, it could raise doubt about the idea's novelty and therefore its patentability. So the first thing to figure out with the NDA is what type of NDA you'll enter into. If only one party is providing the information, then you need to put the obligation to keep silence on the listener of that information. And this is called unilateral NDA or one-way NDA. But you could also have a mutual NDA, also called two-way NDA, where both parties are givers and recipients at the same time, so they both need to keep their silence. Now, I typically see more unilateral NDAs in vendor or consulting arrangements, whereas I probably see more mutual NDAs in joint projects and in M&A contexts. But even in contexts where one party is primarily disclosing the bulk of the information, I found that sometimes it's beneficial to structure it as a mutual NDA because it helps to set the right tone, foster a feeling of fairness, and promotes candid information because both sides are protected from the start. Now, sometimes what happens with unilateral NDAs is that as you discuss more, the original recipient may want to talk about their experience and their stories, which may contain confidential information. And if that happens, you have to sign another agreement to protect that portion, which can be a bit awkward. Another benefit is that a lot of nitty-gritty details like how long does the confidentiality period last becomes less contentious because your obligation also becomes your right. But even then, even in certain situations like employment context, I think unilateral NDA is probably more standard and customary. And mutual NDA, because it places obligation on both ends, it's not completely without risk either. The second thing to focus on is the definition of confidential information. Usually this definition starts out as secrets and non-public information and gives a bunch of examples and covers information given to representatives of the parties like bankers, lawyers, consultants. Of course, there are exceptions to this broad definition, like if the party already knew the information or the information becomes public without anybody's fault, which is all standard and customary. But where people negotiate is whether the information needs to be marked as confidential or not. On one hand, it's not ideal if you forget to identify something as confidential and then loses protection. But on the other hand, if it's not clearly marked, the recipient has to try to figure out what's truly confidential or not. So sometimes it comes down to which side of the table you're on. So if you're the recipient, you want it clearly marked. If you're the disclosing party, you want a broader definition. Of course, you're negotiating leverage, meaning how much they need you versus how much you need them, and what you're comfortable with as an institution matter as well. The final point to keep in mind is the duration of the confidentiality period. So I've seen 1 to 5 years, sometimes as long as 7 or 10. I generally discourage against indefinite duration. Now, having said that, I think 2 to 3 years is probably reasonable for most cases. But trade secrets should be exempt from expiration, and in fact, it should remain confidential forever. What is a trade secret? It's a secret generally unknown to others that provides a competitive business advantage. I think Coca-Cola recipe is a classic example, and so is McDonald's Big Mac sauce rather. In a startup context, I would say source code is the trade secret, unless it's open source, of course. And in a lot of cases, the client list, depending on how easy it is to ascertain from the outside, and whether the organization keeps that information like a real secret. So for example, say only a few people are given access to that information, like the CEO or the CFO, or if the information is password protected, things of that nature. What you don't want though is to have the consultants or competitors who have been given access to your trade secret to make an argument that at the end of the confidentiality period, they can use it or disclose it. That is the scenario that we're trying to protect against with this exception. Now let's go do the deep dive on the document that you'll be drafting in this website. If you understand one document really well, you'll be able to extend that knowledge to similar documents. Make sure that you're watching the video in high definition so you can see the text of the agreement as we read them together. I'll see you there.